The Federal Trade Commission of the Department of Justice's Antitrust Division releasing long-awaited drafts now on guidelines to how they plan to enforce merger law. The guidelines outline 13 principles like mergers should not significantly increase concentration in highly concentrated markets, and mergers should not eliminate substantial competition between firms. It's a watershed document that a lot of folks in corporate America are reading this morning, along with their lawyers. Assistant Attorney General for the Antitrust Division at the Justice Department, Jonathan Kanter, is with us this morning. Unfortunately, FTC Commissioner Chair Lina Khan, who was going to be joining us, affected by some weather travel issues, like so many across the country. But good morning to you. Let's talk about it. What's the intent with putting this document out?
Yeah, thanks. First of all, it's wonderful to be here. Thanks for having me. The intent of this document is to make sure that we are providing transparency to the public about how we enforce the law. I want to be very clear. The law hasn't changed. These guidelines simply explain agency practice and how we apply over a century of court precedent and statutory text. And
so how much should folks think about this as just a blueprint for how you plan to approach it, but not necessarily how the courts plan to approach it?
So that's the beauty of how we've constructed these guidelines. We've started with a full analysis of the law. And so going back to the merger guidelines, which originated in 1968, these are the first guidelines ever to cite cases. And we do so extensively because we want to make sure that we are bringing cases to courts that reflect the facts, but also reflect the law, which is what courts apply when they're looking at our cases.
Uniquely, at least historically, most judges looked at a market, said how concentrated is the market going to be, and importantly, how is this going to impact consumers? Those were always sort of the two basic questions. It looks like in these guidelines, you have expanded the aperture in terms of how you look at these things, including, and I think that's going to be somewhat controversial, there's a bit of crystal ball gazing that may be required to actually think through how, for example, a smaller company, which may have actually, very little power or influence right now, might affect a bigger company merged later down the road. How do you think about that?
Yeah, so merger enforcement, as Congress created in the Clayton Act, is necessarily predictive. And so it's ultimately a risk assessment. We're trying to understand the extent to which the merger will risk threatening competition. And so what courts have said over a century is that if it reduces substantial competition between competitors, or if it tends to create a monopoly by entrenching monopoly power, or building a moat around a firm that already has monopoly power, or increases a trend toward concentration so that the only way to compete is to be massive, then those are exactly the kinds of mergers that can violate the Clayton Act and be subject to legal scrutiny.
How much of this should be considered a political document and an anchoring technique? I say this because, as you mentioned, these documents started being produced back in 1968, different administrations, Reagan in '82, as recently as Trump's DOJ, right before he left, have left these documents in place, and they have evolved. So little pieces of them in different administrations with perhaps different perspectives have sort of pushed through into guidance that's continued.
Yeah, so as you noted, these guidelines have started in 1968, but they were updated in 82, 84, 92, 97, 2010, and 2020. And there's a reason for that. The reason is because markets evolve and the law evolves, and it's important that agency practice evolve to meet the facts in the law where they are. We've gone through painstaking detail to make sure this is not an ideological document. We've gone through painstaking detail to make sure this is a legally rigorous document. And as you read it, you'll see citations to cases extensively. We literally read every single merger enforcement decision by an appellate court and the Supreme Court, and we laid that out and then built the guidelines around those legal decisions. Because the burden is ultimately on us when we investigate a merger to convince a court that there's a problem. Courts are looking at court precedents, and we are looking in them as well, and we are giving courts a framework that courts have used for over a century to analyze mergers.
You know, you can look at laws, one person sees one thing, another sees another. Were you surprised by the recent rulings in two different courts going against the FTC last week, saying that they didn't have the right to shut down the Microsoft merger with Activision, or the Microsoft purchase of Activision?
Yeah, I can't comment on any specific case, but we have great faith in our court system, and it's there for a reason. We have the burden to bring cases before courts and convince courts that a merger may substantially lessen competition or tend to create a monopoly. And that's exactly why we've constructed these guidelines to build around the same precedents that courts are applying. To us, that is the best way to be faithful to the law.
Let me ask you about this, and maybe it's an ideological question, but it's about how you and the FTC approach cases and your willingness, in fact, to perhaps lose the case to maybe gain ground elsewhere. Skadden Arps, the law firm, put out a paper saying, are the FTC and DOJ losing antitrust battles but gaining ground? And it was a very interesting paper because it basically suggested that even in cases where you're losing, there are component parts of these rulings which are going to help you down the line, which is to say, for example, several courts have now ruled that wage fixing and no-poach agreements can be prosecuted criminally. That's something that didn't exist before. Even though you lost the case, you got that. A district court recently held that it may suffice for the government to show in an actual potential competition merger case that the acquirer had the wherewithal to enter the market, not necessarily that it intended to do so. So how much do you think about those issues relative to the case itself?
Yeah. So I'm not familiar with that paper, but let me be very clear. We bring our cases to win. And so when we believe that the facts and the law support legal action, we bring it to a court, and then we give a court or a jury the opportunity to confront the facts and the law and render a decision. And so that's what drives our decision-making. At the Department of Justice, we are a law enforcement agency, and our goal is to enforce the law consistent with the facts and the law.